accrual method taxpayer, you have income as soon as you've provided the services, because after you've
about ready to go to sleep. Justice Scalia went to sleep on me once because I was last.
Welcome. My name is Neil Siegel. I teach constitutional law here at Duke Law School, along with Chris Schroeder. I'm one of the directors of the program in public law, and as part of the variety of activities we provide to the law school community, we like to keep people apprised of what's going on at the U.S. Supreme Court. And so from time to time during the year, we have U.S. Supreme Court updates. Let me set the scene for you, and then I will turn it over to the panelists. So the court's term begins every year on the first Monday in October. This year, the October 2008 term began on Monday, October 6th. And then from October through April, there are what are called sittings, and which is 2 weeks of argument from Monday to Wednesday, except in cases of legal holidays, in which the court hears cases 2 or 3 a day. And we've already had the October sitting, we've already had the November sitting, the December sitting begins on December 1st. The court's calendar is filled through January, and we're still waiting to see what the calendar is going to look like February, March, and April. We are not going to try and be comprehensive. There are already more than 60 cases that have been granted, some of which have already been argued, and one of which has been decided, I believe, so far this term. So we're not going to just throw cases at you, but I do have a distinguished panel of experts in particular areas of the court's docket, and they're going to share with us their views on at least some of the cases that are before the court this term, and also, I think it's fair to say, some of the most important cases. We'll begin with Professor Katharine Bartlett. She's the A. Kenneth Pye Professor of Law. She serves as the Dean of the Law School from 2000 to 2007. She teaches family law, employment discrimination law, gender and law, and contracts, and she publishes widely in the fields of family law, gender theory, employment law, theories of social change, and legal education. She is widely regarded as a leading authority in the nation on the law of sex discrimination, both constitutional and statutory, and she'll be speaking with us today about some of the most important sex discrimination cases on the court's docket this year. After Professor Bartlett, Professor Lisa Griffin will be speaking to us. She joined our faculty in 2008. She teaches in the areas of evidence and criminal law and procedure, and her writing, her scholarship focuses on federal criminal justice policy. Her academic interests in white-collar crime and in the role of the jury stem from her experience in practice, specifically as a federal prosecutor. She served in the U.S. Attorney's Office in Chicago from 1999 until 2004. We are very lucky to have successfully recruited Professor Griffin to our faculty. After Professor Griffin, Professor Schroeder, Chris Schroeder, the Charles S. Murphy Professor of Law and Professor of Public Policy Studies at Duke. He'll be speaking with us. He is a leading expert in the areas of environmental law as well as constitutional law, and within constitutional law specifically in the area of executive power. He's the author of a leading environmental law casebook, as well as a co-editor, along with our own Kurt Bradley, on a recent book on presidential power called Presidential Power Stories. Chris Schroeder, like many of the faculty here at Duke, has served in government, acting Assistant Attorney General in the Office of Legal Counsel at DOJ, as well as Chief Counsel to the Senate Judiciary Committee. He'll be speaking with us today about some of the environmental cases on the court's docket this term. And finally, Professor Ernie Young is going to be speaking with us about some of the preemption cases, the very important federalism cases on the court's docket. This year, he teaches constitutional law, federal courts, and foreign relations law. He is one of the nation's leading authorities on the constitutional law of federalism. He's also an active commentator in the area of foreign relations law, and he also writes on constitutional theory, constitutional interpretation. And when he's not doing that or rooting for Texas football and now Duke basketball, he also has been known to dabble in maritime law as well as comparative constitutional law. So without much further ado, Professor Bartlett.
Thank you, Neil. First, I want to say, those of you I see who were in my 1 o'clock class, that we are starting class on time. I'll be leaving early, and you can leave with me. So as compared to previous years, this is not a year with big headliner cases in the sex discrimination area. There's no big abortion case, no big equal protection constitutional law case, no case yet on sexual orientation. So these are important cases I'm going to mention, but perhaps not ones that you've read about in the newspaper. First, there are 2 sexual harassment cases, and then there are 2 pension cases, only one of which I'll be mentioning in that, only if I have time, that have a gender issue. I believe that since 1986, yeah. Can I get any closer? A little uncomfortable. How's this? Is that any better? Thank you. So since 1986, I believe that there have been more sexual harassment cases, perhaps than any other type of sex discrimination case decided by the Supreme Court. There are 2 this year, one in the employment area and one in the public school area. Now, if you've been following this area, you know that these 2 areas of the sexual harassment law in these 2 areas have been moving in different directions. In order to make out a case under Title IX for sexual harassment, either by a teacher or by a fellow student, plaintiff needs to show that the school system has been deliberately indifferent to the harassment. Whereas in the employment area, the court has issued a number of very protective decisions, and you'll hear a little bit about that in a minute. I want to start with the Title IX, with the educational setting. As I mentioned, the standard has been deliberate indifference. It's been such a tough one to satisfy this standard that plaintiffs are looking for another remedy, another cause of action that might work better. So in the case this term, Fitzgerald versus Barnstable School Committee, the plaintiffs are trying their luck with a Section 1983 claim. This is a case that concerns a kindergarten school girl who complained of repeated instances of having a 3rd grader lift up her skirt, pull down her pants, spread her legs, that sort of thing. After about 6 months, the girl reported it to her parents, who immediately went to the school system. The school system began an investigation parallel with the police. The police determined that there was no criminal activity, so the school decided not to take any disciplinary action, but they did offer the parents that the girl could either take a different bus or sit segregated with other kindergarten children from the older kids. This did not satisfy the parents, so they brought an action both under Title IX and under 1983. The district court, affirmed by the First Circuit, dismissed the Title IX claim on the grounds that the school hadn't shown deliberate indifference, and they dismissed the 1983 claim on the grounds that Title IX was meant to be the comprehensive statute that Congress intended to deal with discrimination, including harassment in the school system, so that they were out of luck. They were foreclosed from bringing a separate 1983 action. So that's the issue, whether or not, as an alternative route, victims of sexual harassment in the schools can make out a 1983 claim in addition to a Title IX claim. And what's going to be at stake here is whether or not the plaintiffs can convince the court that Title IX was not meant to be the comprehensive, to have the comprehensive enforcement procedures that would signal an intent to displace 1983. So a lot of things that are being argued about here, but what the plaintiffs are trying to do, and what the First Circuit has already rejected, along with a few other circuits, the circuits are split on this, is whether or not, because Title IX didn't originally even create a private right of action, that had to be implied, because the people you can sue are different under each statute, because there were exemptions under Title IX, like military, educational institutions, and single-sex schools, whether there are enough of these differences such that 1983 will be considered an independent cause of action, not foreclosed by Title IX. Okay, let me go over to the employment case. So, as you undoubtedly know, Title VII protects employees against sexual harassment and also from retaliation when they complain about that harassment or any other form of sex discrimination. So in the case of Crawford versus Metropolitan Government of Nashville, this raises the really interesting question of whether a woman who complained of, who was arguably retaliated against because she complained about sexual harassment in somebody else's sexual harassment complaint, whether she has the protection that Title VII offers from retaliation. In this case, she was called in as part of an investigation when one of her coworkers complained about a particular person harassing her. She said, yes, that person has also harassed me, and gave facts that would support a pretty significant case of sexual harassment. I won't go into those details, but the day that the report was filed, the investigative report was filed, the company undertook to investigate her for something else and then fired her. So the question is, was that retaliation? That would, of course, have to be proved to a jury, but the question is whether or not she's even entitled from the statute's retaliation protections. It sounds like a pretty obvious question that ought to go to the jury, but under Title VII, protection from retaliation, as all of you in my employment discrimination class know well, is available only when the retaliation was in response to two types of activities. One, opposing a violation of Title VII, or two, participating in an investigation under this title. The Sixth Circuit denied her retaliation claim because, one, she didn't file her own internal complaint, so she didn't make out the opposing prong. You have to oppose a violation of Title VII. And two, the investigation was still an internal investigation. It wasn't an official EEOC investigation, and the courts pretty consistently have held that the participating prong means participating in an EEOC proceeding. So she's kind of edged out of both of the prongs which are provided under Title VII for retaliation protection. I think there's a reasonable chance of, oh, I didn't give my opinion on the other case. Are we supposed to give our opinions and predictions?
Sure.
Okay. I don't think I think the school case is going to be a real stretch. I just think that the court's not going to want to revisit all of the policy and the considerations about the limited financial wherewithal of school systems and how difficult it is for school systems to monitor the behavior of teachers, but especially other students, that they're really not going to want to open up another can for plaintiffs to seek relief. I think the plaintiffs in this employment case have a reasonable chance of reversal. The court has really elevated through, in a number of different ways, the importance of internal complaint procedures. They want parties to use them. They require parties to use them if they're available. They're required to use them if they want to have, if they're seeking vicarious liability against the employer for supervisor harassment. And they've also been very protective of retaliation, and they've defined it in fairly generous terms. So if you sort of follow the direction, then they should win. But maybe not, because the question is it exercising your rights, your own rights, when you complain in the context of somebody else's complaint procedures? So I don't know, but I think that one's, the plaintiffs are far likely to get reversal in that case than the plaintiffs in the school case. I see I have another minute to cover the pension, one of the two pension cases. And this case is significant insofar as it relates to the Lilly Ledbetter case that we heard a fair amount about in the last election. So this is a case from the Ninth Circuit which concerns whether employees who took a pregnancy leave before the federal act made pregnancy discrimination a form of sex discrimination. That was all the way back in 1978. This woman takes a pregnancy leave. It's not treated as other disability leaves are treated, which means when it comes time for figuring out her pension, she's not given service credit for that period of time in which she took a pregnancy leave, whereas if she had had another kind of disability leave, she would have had pension service credit. The Ninth Circuit decided that since the Pregnancy Discrimination Act was not retroactive, it's clear that it's not, the plaintiff is not entitled to the benefits of the act before it was passed, and that because this differential treatment of pregnancy occurred over 30 years ago, well beyond the statute of limitations period, and so no relief. The Ninth Circuit then met en banc to reverse the panel decision, and they gave summary judgment for the plaintiffs based on the theory that the decision that matters here, that is the computation of her pension amount, was not the pre-Pregnancy Discrimination Act failure to grant the disability leave, but rather the post-Pregnancy Discrimination Act decision to award benefits by a method that discriminated based on pregnancy. So the plaintiff's case makes a certain amount of sense. Unfortunately, there is a fairly long line of precedent, including the Ledbetter case, which works against the plaintiff in this case. The case most on point is a 1977 case, which you may hear more about, United Airlines versus Evans, where it's really very comparable. There, the woman was fired because she was married at a time when firing somebody because they were married was not illegal. It later becomes illegal, and then when a question related to her seniority comes up, the question is, does the seniority based encompass that period before she was illegally fired? And courts have distinguished between single acts of discrimination to which the statute of limitations applies, which is most things, including getting paychecks and getting fired, getting hired, that sort of thing, and continuing acts like a mounting case of sexual harassment where you might be able to include events that are outside the statute of limitations. So the Ledbetter case, as I mentioned, which you may know the facts about, where this was a woman whose present pay or whose last paychecks were based upon a number of discriminatory evaluations that took place a long time ago, and the court in that case held she can't complain of the behavior a long time ago. The paychecks are new events, and that if those weren't themselves based on discriminatory intent, then she doesn't have a cause of action. So I think that line of precedent is likely to be followed by the Supreme Court in this case. I think Congress is likely to take action based on the attention given to the Ledbetter case, and it's possible that any attention they give that case will also affect the fact situation in this one.
Thank you, Professor Bartlett. Now Professor Griffin will speak to us about some of the criminal cases on the docket this year.
Thanks. So this term is a unique term in that it's hard to pinpoint a single case that is garnering a lot of attention. There's very little this term that has attracted the sort of attention that last term's decisions on Guantanamo, on the Second Amendment, on lethal injections garnered. There was an early article in the New York Times previewing the term before anything had been argued, and it called the term a buffet with no entrees. And I think actually that's not true of criminal law, though. I think that this term, criminal law, is a little meatier than some other areas of the docket. There's nothing nearly as colorful as the FCC obscenity case, or as the question whether the 7 aphorisms monument will be treated the same as the 10 commandments monument. But nonetheless, the court has some heavy lifting to do in the criminal law arena. There is a full complement of what I think of as sort of workaday cases in criminal law, concerning everything from the validity of a search incident to an arrest when the suspect is already handcuffed and sitting in the back of a squad car, remedies for things like flawed jury instructions and for violations of plea bargains, habeas issues, including procedural default, statute of limitations, and ineffective assistance of counsel, the scope of qualified immunity, speedy trial rights. There are a couple of cases concerning the suppression of voluntary confessions. There's a case concerning peremptory challenges to jurors. Another one that was just granted, which is an interesting case on the collateral estoppel effects of hung juries. And there are some, as there are every term, there are some important statutory construction issues, like whether the failure to report to prison is comparable to an escape for purposes of the Armed Career Criminal Act, the meaning of domestic violence for purposes of the prohibitions on gun ownership, and the knowledge standard for identity theft, which is an increasingly important offense, as well as an interpretation of the racketeering statute, the RICO statute, in terms of the meaning of association in fact. That very quick litany was on purpose. The nature of that quick rundown indicates that some of these issues are perhaps narrow, perhaps dry. They're definitely focused. They all, though, will have important implications for criminal law on the ground and criminal law in the lower courts. I'm not going to talk about any of those cases in detail, though, because there are 3 cases pending that I think are more interesting for a number of reasons. They're of particular interest because they represent the Supreme Court continuing ongoing discussions about important constitutional issues. The cases in and of themselves are not so much articulating constitutional rights as engaging in aftermarket modifications to constitutional rights that the court has articulated in recent years. There are 3 in particular, one concerning the Fourth Amendment exclusionary rule, and 2 concerning the Sixth Amendment. One, the Confrontation Clause, it's basically an evidence case, and another concerning the Sixth Amendment right to a jury trial in terms not only of liability, but also of sentencing. And these are cases that are interesting for 2 reasons. One, they have unconventional alignments among the justices in terms of where they stand. They also have the advantage of all 3 having been argued, so I can say a little bit more about them than it's sometimes easy to say in terms of predictions. I don't have a very good track record making predictions on the Supreme Court's going to do, and I try to avoid it. Occasionally, oral argument will give you some additional tea leaves that you can read from, and it's about as accurate as in fact reading tea leaves, but it does help you to think a little bit more broadly about what the discussion is that the court is having. And in all 3 of the arguments in these cases, we can see the alignments, particularly Justice Scalia has been very interesting on the Sixth Amendment because he has sort of led the charge for reinvigorating it, both in terms of the Confrontation Clause and the evidence implications of that, and in terms of the jury's role in sentencing. And these are fairly recent conversations that the court has engaged in. It'll be interesting to hear Justice Alito and Justice Roberts' voices on the jury's role in sentencing. We've heard a little bit from them about the Confrontation Clause, less about that. The Fourth Amendment case is actually that's been going on for almost 50 years. There's been mounting pressure since Mapp versus Ohio in 1961 on what the remedy is for Fourth Amendment violations, and the Herring case is about the exclusionary rule. So I'll give you some summaries of those cases, and I'll tell you what I think is the second interesting thing about this group of cases is that they represent in one direction in terms of the Fourth Amendment an incremental, long time coming, curtailment of rights. There are a handful of justices who are very skeptical of the exclusionary rule in general. Justice Scalia, very vocally, apparently Justices Thomas, Alito, and Roberts as well. I don't think there are votes to overturn it, but case after case, we're seeing this incremental contraction of that right. In the Sixth Amendment arena, we have a much shorter time period between the articulation of the reinvigorated Confrontation Clause and the jury's role at sentencing, and the remedies for that, and the scope of that. And in that short conversation, we've seen expansion of that right. So, with the caveat that I'm reluctant to make predictions, I think probably we're going to see this incremental curtailment of the exclusionary rule in the Herring case, and a slightly more significant expansion of Sixth Amendment rights in the Melendez-Diaz and Oregon versus Rice cases, respectively. So quickly, the Herring case is about whether there is a good faith exception to the exclusionary rule for searches based on misinformation obtained from other police departments. As a general matter, when police misconduct leads to the seizure of evidence, that evidence is suppressed in court on the theory that it will deter such police misconduct. There is a 1995 case, Arizona versus Evans, in which the court said, well, if there's a clerical error, if a court employee erroneously issues a warrant and the police act in good faith on that warrant and arrest someone, that the fruits of the search incident to that arrest don't need to be suppressed because it wasn't police misconduct, and that wouldn't have any sort of deterrent effect. The Herring case is interesting because it was actually the police department that made an error about the warrant. In the Herring case, a neighboring county in Alabama informed the police department that there was a warrant for someone's arrest. They called back about 15 minutes later to say, oops, that warrant was withdrawn 5 months ago. But in the intervening time period, they had arrested Mr. Herring, they had searched him, they had found methamphetamine and a firearm, and he was convicted of possessing the methamphetamine and being a felon in possession of the firearm and sentenced to 27 months. So his claim is that evidence should have been suppressed because of the error. And the court is engaged in this debate about whether borderline negligence from a neighboring police department is the sort of conduct that imposing an exclusionary remedy can deter. And there seems to be a debate about the virtue of a bright line rule, either saying there's strict liability for any misconduct by the police, whether it's negligent, whether it's isolated, whether it's from a neighboring county or not, or at what Scalia seems to favor, saying there's no exclusionary rule at all. Those would both be very workable bright line rules. The argument indicates there's probably at least a plurality of justices who are willing to look at this on a case-by-case basis, or possibly will rule for the government that when there is isolated negligence through no fault of the particular police department issuing or executing the warrant, then in fact courts can engage in that sort of case-by-case analysis and that the exclusionary rule won't apply here. The Melendez-Diaz case is the Sixth Amendment case about whether crime lab reports are testimonial within the meaning of the Sixth Amendment and therefore have to be cross-examined in court or at some prior opportunity for the defendant. Mr. Melendez-Diaz's case is pretty typical. He was convicted of the possession of crack cocaine, and the testimony at issue is of a lab chemist who determined that there was in fact cocaine in the substance that was found during the course of a search involving his arrest. And traditionally, these types of reports have come in through certificates, through summary testimony. This is a case that's going to have huge impact because it affects everything from DNA analysis to ballistics reports, fingerprints, hair analysis. Any sort of forensic lab report will be implicated here. And the court has very slowly after articulating this right to cross-examine where testimony is in fact accusatory in some meaningful way, is proceeding in the direction of making it a more and more robust right. My sense from the argument is that even though a lot of justices have expressed concern about the slippery slope that we might be going down, that they will declare that you do in fact have to bring in chemists or technicians to testify to the content of lab reports. And I still think that will be the rare case where that actually happens and that the administrability issues the court is concerned about will not necessarily come to pass. The confrontation clauses for the extraordinary case where there's the potential for government misconduct, which of course there is when you have flawed data going into lab reports or subjective analysis, reading them. And finally, in Oregon versus Rice, the court is again considering the Sixth Amendment and whether sentences, if they're going to be imposed consecutively instead of concurrently, have to be, whether the decision to impose them consecutively has to be a decision of the jury rather than of the judge. It's historically been a judge's decision, but again, since Apprendi in 2000, the court's been engaged in an 8-year-long discussion of the scope of the jury's role in sentencing, and there seems to be a certain amount of impetus behind the idea that even this decision, historically one for the judge, because it has such a profound impact on sentences. In Mr. Rice's case, what could have been an 8-year sentence became a 28-year sentence, then in fact this is something that the jury has to find. And again, justices like Justice Breyer and Justice Kennedy have expressed a lot of concern about whether this will now apply to forfeiture and probation and other areas where there are significant impacts on defendants. But I think that the originalists here have will probably carry the day and continue to expand the jury's role in that area.
Thank you very much, Professor Griffin. Very briefly, she mentioned two cases that are important that we're not covering. The first is FCC against Fox television stations, which raises the question whether the Federal Communications Commission gave an adequate reason for changing its policy and allowing fleeting expletives, like the F-bomb on TV, to qualify as indecent under federal law. And the second case she mentioned, dealing with privately donated monuments, is Pleasant Grove City, Utah against Summum. And there the question is whether, under the First Amendment, a privately donated monument placed in a public park qualifies as private speech or government speech. So it's a First Amendment speech case, but it also has Establishment Clause undertones because of the monuments at issue, of the Ten Commandments versus the 7 aphorisms. Professor Schroeder now is going to speak to us about some of the environmental cases on the docket.
Thanks, Neil. Last term was a great term for environmental organizations in the Supreme Court. The court decided no environmental cases. This year is going to be a bad term. The court has 5 environmental cases before it, and whenever the court takes a case, environmental groups wince because the court has never been particularly green. So this year with 5 up, everybody I know is cowering in the corner, wondering what's going to happen. I'm going to talk to you about two cases which were argued on the same day on Wednesday, first Wednesday of the term, which the people around the courthouse call the summer and the winter cases. The first one is Winter as Secretary of Navy versus the Natural Resources Defense Council. The case dealt with whether or not the Navy could proceed with massive training exercises off the coast of Southern California before they had complied with the requirements of the National Environmental Protection Act. That act, since 1969, has required federal agencies, before they undertake a major federal action, to analyze the environmental impacts of that action through an environmental impact statement. There's no substantive constraint on what agencies can do. They can look at the environmental issues and decide to go ahead as they please, but the rationale behind the statute is that agencies are supposed to look before they leap in making decisions, with the expectation, but not the command, that, of course, sensible and rational agencies, if they found severe environmental impacts, would in fact adjust their behavior accordingly. The problem that the Navy had was that they insist that they need to train their active sonar operators in these naval exercises. And the problem is these darn enemy subs, which can operate for long periods of time on battery power and give off indetectably small amounts of noise themselves. So you have to use active sonar, which sends out a sonar pulse at various frequencies and then wait for the return and analyze the bounce back as to whether or not it's a hostile sighting or not. It's a skill that has to be trained. The sonar operators have to be able to discriminate from all kinds of other things that are happening under the ocean and identify a potentially hostile sub. The only feasible location for conducting these live exercises is off the coast of Southern California for various reasons that weren't challenged in the litigation. But the problem with that location is that it's also home to a lot of marine mammals, dolphins, various species of whale, seals, all of whom are very sensitive to the frequencies produced by these sonar pulses. So recognizing this, the Navy had on its own voluntarily instituted a number of mitigation techniques, including posting lookouts during these exercises who would give warnings if they spotted dolphin schools swimming on the surface or other activity that might indicate the presence of mammals. And they'd shut down the sonar if any activity was within 200 yards of a ship. So the Navy wanted to undertake another training exercise this fall and do so under its voluntary mitigation techniques. It had eventually, as a result of the litigation, agreed to prepare a full environmental impact statement, which it had never done before, but it hadn't completed it prior to the time the exercises were to begin. So the NRDC sued to obtain a preliminary injunction Since, of course, the only purpose of the National Environmental Policy Act is to have these environmental impact statements prepared before you act, it seemed like that was a sensible request to make. The district court did ultimately enter a conditional preliminary injunction against the Navy, preventing them from conducting the exercises unless they instituted still more protective measures, one of which was to enlarge the 200-yard protected area to 2,200 yards. The Navy said it couldn't conduct live exercises under those conditions, went to the Ninth Circuit to try to get some relief, actually went to the President and got some emergency relief. People thought this case might be a case about executive power, as whether the President could override a district court injunction. It ended up not being germane to the way the Supreme Court, I think, is treating the case. I'm not as timid as my other colleagues. I can predict with utter confidence the outcome in this case, since it was decided last week. The Navy won 5-4, with the Supreme Court holding that the district court had not given sufficient weight to the needs of the military. In an opinion by the Chief Justice, the court held that this interest, the interest in national defense, security, and readiness, outweighed the more speculative harm that the plaintiffs claimed that they would suffer. Now, an important part of this case has to do with the law of standing, which is one of those topics that causes my students to wince and maybe even cower in the corner when we talk about it. So standing law requires anyone who wants to sue a federal agency to challenge its action, that individual be personally affected by the agency action. So the implication of this in a case like Winters is that the plaintiffs were not bringing a suit directly on behalf of marine mammals. They were suing to protect their own uses of those mammals. So one of the plaintiffs, for instance, was Jean-Michel Cousteau, who complained not about the loss of marine mammals directly, but rather about the loss of his opportunities to film, study, or be educated by the mammals. The one consequence of this is that although the Navy conservatively estimated that some mammals would be indeed harmed by the active sonar, whether that loss would be of a sufficient magnitude to deter Monsieur Cousteau's ability to engage in his education or filming opportunity, the court thought was more speculative. Now, the influence of standing law on Winters was real, but it was relatively minor in the case because of the heavy emphasis that Justice Roberts' opinion puts on how important the national security aspects of the case are. In fact, Winters is an excellent example of what I call the first substantive sentence rule, which is you can usually tell how a case is going to come out if you read the first sentence of the court after it gets done telling you the procedural history of how it got there. In Winters, that sentence reads, it's a quotation from George Washington, "To be prepared for war is one of the most effectual means of preserving the peace." After that, you know the mammals are going to lose. So much for winter. Now on to summer. Summer versus Earth Island Institute. This litigation is almost entirely about standing. The case involved a challenge to some Forest Service regulations. Now, in the Forest Service context, the requirement that a plaintiff be personally affected by the agency action in order to sue translates roughly into a requirement that a plaintiff be found who is actually going to use or has used and will use in the future the part of the geographical land mass that is going to be influenced by the Forest Service regulations. Doesn't take much, hiking, skiing, camping, studying wildlife, but some actual use is required as opposed to just sitting in your home in Durham, North Carolina and objecting to the possibility that some activity is going to be taking place in a forest in Idaho. So summers involved the challenge to a law that Congress enacted in 1992 that requires the Forest Service to establish a system that gives the public notice and an opportunity to comment on, quote, proposed actions implementing land and resource management plans, and then also to provide an administrative appeals process for anybody who participates in that notice and comment period. Potentially, the language sweeps in a broad range of activities, including, for instance, mowing the lawn of a forest ranger, if that activity has been covered by a land resource plan. And so the Forest Service thought that it was appropriate to categorically exempt some de minimis kinds of activities. The problem was the plaintiffs charged that they were exempting things that weren't de minimis and shouldn't be categorically exempted, and they sued to challenge the statute, that the regs is inconsistent with the statute. So in order to satisfy user standing, they had to find a plaintiff who would be able in an affidavit to honestly aver that he or she had used one of the specific geographical locations that the exemptions would affect. And they found such a plaintiff. So far, so good. But then the Forest Service settled the complaint against this particular discrete action by saying, well, as to that one, we'll prepare an environmental impact statement, which is what the plaintiff had wanted. So now the question remains, does the plaintiff still have standing to challenge the sheer illegality of the regulation? Can the plaintiff make what's called a facial challenge against the regulation, not tying it to any particular discrete land-based decision, but rather challenge the regulations as a whole? The district court ruled that the plaintiffs have continued standing to challenge these regulations. It said the challenge is ripe for adjudication. It's largely, if not purely, a matter of law instead of fact, notwithstanding the fact that the specific user-based disagreement of the plaintiff and the Forest Service had been resolved. I predict this case gets decided adversely to the environmental interest too, on probably exactly the same 5-4 distribution that decided the Winter case. So the devil's going to be in the details here. How broad a rule is the court going to announce, if I'm right, in being critical of the district court decision? It's potentially a big deal because it affects the ability of environmental groups to obtain a judicial relief on a range of possible nationwide regulations. If an agency can avoid review simply by agreeing to satisfy whatever action the plaintiff's complaint sets forth as relates to the individual situations where the plaintiff has standing, you can see why that would be a decision that the environmental organizations would wish come out the other way. But I think their arguments in the face of one of the emerging features of the Roberts Court, I think, is that there's a fairly consistent 5-person majority that looks at some of these standing issues, the extension of making the availability of litigation challenges available to third-party organizations, parties who aren't the regulated entity themselves, more difficult, is beginning to solidify. It didn't prevail in Massachusetts versus EPA, the case that the court decided 2 terms ago, which took a more liberal position on standing, largely because the 5th person in this constellation that has to form the majority, Justice Kennedy, thought the standing complaint in Massachusetts versus EPA was solid. But in this more technical regulatory area, I'm skeptical of the prospects for the environmental organizations prevailing.
All right, thank you. And now Professor Young will speak to us about a subject near and dear to his heart, preemption.
So I was at a clerk reunion a couple of years ago, and Justice Souter gave his annual talk about what the term had been like, and he's just going on and on about how they'd had all these really exciting terms with big cases in previous years, and everybody was really tired, and how nice it was that they didn't have any interesting cases this year, and everyone could kind of rest, and he thought that was just great. And unfortunately, his current clerks for that year were standing up at the front of the room next to him, and they're just looking progressively more and more bummed out as he goes on, because, of course, it was the most exciting year of their lives, right? And here's this guy saying it's all boring and there's no good cases. In the federalism area, it may be one of those years in the sense that there are no big-time federalism cases. So at least so far, we don't have a big Commerce Clause case. We don't have a big case under Section 5 of the 14th Amendment. We don't have a big 11th Amendment case, which would just make the year for me. But I think it's a good case. It's a good year to illustrate something Justice Breyer said a few years ago, and nobody knows about this statement from Justice Breyer because he hid it in an ERISA preemption case, and nobody reads ERISA preemption cases. But Justice Breyer said that the true test of Federalist principle comes not in Commerce Clause cases or cases under the 11th Amendment, but in the statutory cases that form the ordinary diet of the law. And this term, I think, is a term about the ordinary diet of the law and the ins and outs of the statutes that more and more draw the boundary between federal power and state power. And I want to talk about two of them. One is Philip Morris versus Good, which is a case about low-tar cigarettes. In that case, the court has to decide whether the FTC's regulations on low-tar cigarettes, which allow certain cigarettes to be advertised as low-tar, preempt state causes of action for unfair trade practices or deceptive marketing and things like that. And then the second is Wyatt versus Levine, which is another products liability case. It's about a woman who was a musician who was experiencing nausea and goes into the emergency room to be treated for nausea. She's given a certain drug. They end up administering the drug wrong. It causes gangrene in her arm, and she ends up, she goes home with one less arm than she entered the hospital. And she, not surprisingly, sued. And the question is whether the FDA's approval of the warning label on that drug preempts any further state tort law scrutiny for failure to warn. Both these preemption cases, I think, are illustrative of the fact that more and more federalism is about not what Congress could do under the Constitution, what is the potential reach of their power under the Commerce Clause, for instance, but about what Commerce has done. There increasingly aren't meaningful constitutional limits, and so the breadth with which federal statutes are interpreted is going to be the key question in determining how much room there is for state action. And the court decides 2 or 3 of these preemption cases a year. I think it's by far the most important part of federalism doctrine. The problem is that in order to get into it, you actually have to understand what's going on in the statutory schemes. And before I go any further, just by note of full disclosure, I was counsel of record for amicus briefs by scholars in both of these cases, so I may have a somewhat biased perspective, even if I didn't already. So let me just run through some of the issues that are raised in these cases. The first set of issues concerns how do we construe federal statutes that are said to preempt state law. And one very big issue that I doubt the court will actually decide is the validity of something called the presumption against preemption, which is a rule of statutory construction that's been around since the 40s that says when somebody argues that a federal statute preempt state law, we have to find a clear intent of Congress to actually preempt state law. So it's a thumb on the scale in terms of statutory construction. That Congress's intent needs to be clear if it's going to preempt state law. And in Wyatt, at least, some of the defendant's side briefs, in particular various amicus briefs filed by industry groups that are generally in favor of broad preemption of state tort law, have argued that this presumption against preemption is unconstitutional, that it is inconsistent with the original understanding of the Supremacy Clause. And one reason I note this is, and why it's a red letter day that this argument is bouncing around at all, is that it's an instance, a very rare instance in which people are actually paying attention to what academics say. Because my friend Caleb Nelson is the progenitor of this argument at the University of Virginia, has argued that the Supremacy Clause incorporates a certain characteristic phrasing from the founding period that said you're not supposed to have any thumb on the scale against repeal of pre-existing law. And so the argument is that this the presumption against preemption, which develops much later, is inconsistent with that understanding of the Supremacy Clause. Now, this argument does point up one rule of thumb, which is that if you want to cite academic research in briefs, you really ought to read the entire article before you cite it, because actually Professor Nelson's position is that preemption should be a lot narrower for other reasons, and including reasons which would cause the plaintiffs to win in this case. But there's a lot of arguments about the presumption against preemption, and I doubt the court is going to say anything categorical one way or the other about whether it's valid. And the second, narrower issue, this comes out of Good, is the effect of the preemptive effect of of specific federal statutes on generally applicable state laws. So, for instance, the cigarette statute is a very targeted restriction that only bears on cigarette advertising. And all the FTC regulations themselves are also particular to cigarette advertising and preempt things that are particular to the problems of health arising from cigarettes. The question is whether something like that is so narrowly targeted, should be construed to preempt a generally applicable state law, like a general law that prohibits unfair trade practices. So if the general state prohibition isn't tailored to health effects of cigarettes or anything like that, but just simply says, don't lie when you advertise, is that preempted by such a narrow prohibition on health advertising or health liability for cigarettes? And essentially, the industry is arguing that every generally applicable state law has to have this little carve-out for cigarettes that would allow anything to go. The second cluster of questions, I think these are probably the more important set of questions, has to do with what is the role of administrative agencies in preemption cases. So in the Good case, for instance, the industry has argued that the FTC's grant of authority to regulate aspects of cigarette advertising and health concerns is an exclusive grant of authority. And now the statute doesn't say this clearly, and the question is really how ready should we be to interpret Congress when it delegates authority to a regulatory agency as delegating exclusive authority over the subject matter, and when should we assume that those grants are concurrent, that the states would retain their traditional authority to regulate. The second, more narrow version of that question occurs in Wyatt, and that is when a federal regulatory agency approves something, when they approve a particular drug or when they approve the labeling that goes out with the drug. These approvals occur prior to the marketing of the product. And the question is, what should the effect of these pre-market approvals be on post-market liability? Is the FDA's decision in a case like this meant to be a pre-market screen? It's one hurdle that you have to clear in order to get it out onto the market. It's one way of preventing a large number of problems by requiring this pre-market screening, but not the only way, perhaps, and might still allow concurrently that there would be back-end regulation by the states, especially through tort law. Or should we take the federal agency's approval as just a definitive judgment for all time on the validity of that product or the validity of that label? Should it preempt any other effort of regulation, whether it occurs in some very different form like state tort law? A third question is the degree of deference that an administrative agency should get when it construes its underlying federal statute to preempt state law. In those cases, the agency is making much the same determination that a court might make. It's interpreting the statute itself, not its own regulations. It is interpreting Congress's intent to preempt state law. Not surprisingly, when the agency interprets the preemptive intent of a federal statute, it tends to interpret that intent fairly broadly. That tends to augment the administrative agency's power. And so the question is whether the traditional deference that agencies get when they interpret their statutes should yield to the baseline presumption against preemption. And this is an issue that has been fertile fodder for academics and student notes for many, many years. In a way, it would be disappointing if the court actually resolved it, because then we'd have to find something else to write about. My prediction is they won't resolve it. And then the last question is what sort of agencies' actions on their own can preempt state law? So agencies don't just interpret the underlying federal statute, they also take actions of their own, they promulgate their own regulations, and sometimes those are said to preempt state law. What sort of action by an agency should it take? It's certainly true that certain agencies' actions have the effect of federal law under the Supremacy Clause, including preempting state law. The question is, how formal should that action be? Should it only be rules that go through notice and comment rulemaking, for instance? Or would something like the FTC's policies about low-tar cigarettes that aren't formalized in any kind of rule, should those have their own independent preemptive effect? I generally try not to make too many predictions. I've basically made one really sound, really sure prediction in my life to a class, and that was that the Supreme Court would never, ever take Bush versus Gore. So I try to avoid these things. I will predict that the alignment in these cases might surprise you if you've been paying attention to federalism cases in the big context of Commerce Clause litigation or Section 5 litigation, in which the conservatives tend to rule for the states and the nationalists tend to rule for, or the liberals tend to rule for the national government, that's likely to be flipped here because of the odd dynamics of preemption cases. I think, if I must make a prediction, I'm going to predict that the plaintiffs are going to lose both these cases, but that's not so much based on a judgment about what's likely to happen actually as simply hedging my bets, and that way I will either be happy about the outcome or, what's even more satisfying to an academic, happy about being right.
Well, thank you very much. So we've learned that even in an economy that's struggling, betting on the outcome of Supreme Court cases is not a good way to plan for retirement. So you keep that in mind. We have 5 minutes, and so we have some time for maybe a question or two. Any questions? Okay, I think we've, yes, are you, yes?
Sorry, I'm curious about the exclusionary rule. I seems to be being more and more curtailed. I know that a lot of that is kind of led by Justice Scalia right now.
It is.
But from my understanding of his basis, he's basing it on economic, I guess, law and econ, which he doesn't seem to fully understand. Because the law and econ literature all suggests that tort law was always available as a deterrent, but the way that qualified and absolute immunity is evolved, that's no longer an accurate deterrent at all, or an effective deterrent. So how exactly, like, what is going to keep, I guess, the police state from just taking over?
So the reason that Justice Scalia is credited with this position is the Hudson case from 2006, in which he very clearly indicated his preference for overturning the exclusionary rule altogether. And I think the answer to your question, although I don't know how satisfying it will be to you, is that the traditional answer is that even absent the exclusionary rule, that police officers are not going to engage in unlawful arrests because, one, it's dangerous to do arrests, particularly if you're using erroneous information to go forward with those, that it may be fruitless from an investigative standpoint. They don't want to waste resources, that they're subject to internal discipline, and that there's the possibility of civil liability. That came up in the argument in hearing. Justice Ginsburg asked, has anyone ever prevailed in a civil case in one of these situations where there was good faith reliance on a erroneous warrant? And the answer that there was no good answer to that question because there really isn't a case that anyone can think of. But those are the traditional responses to that, which is rather than going all the way back to the Leon case, the notion has been that in order for the exclusionary rule to apply, its benefits have to outweigh the costs. The costs are considered loss of evidence and potentially freeing criminals, and the benefits are deterring police misconduct. So the question is always, and it's a question Justice Breyer actually asked at the hearing argument too, how are you deterring police misconduct if no one did anything wrong here, since it was based on sort of marginal negligence from some other jurisdiction? So the answer to your question, and the answer that's always given, is even without the exclusionary rule, they would avoid this sort of misconduct because they don't want to waste their time on bad arrests, be disciplined internally, or be subject to civil suits. It's not entirely satisfying, though.
Okay, well, I want to thank our panelists very much for devoting their scarce time